Hello, everyone, and welcome to the second session of ELI Summer School 2021. Today, our session is on Nepa, ESA, and the fundamentals of environmental law. My name is Nina Pusick, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute. I would like to take a moment to thank our outstanding panelists for joining us today to lend their expertise to our second summer school session and to kick off our first academic session of the summer. The session serves as an introduction to the fundamentals of environmental law and reviews two major statutes, the National Environmental Policy Act, or NEPA, known as the Magna Carta of environmental law, and the Endangered Species Act, or ESA, known as the Pitbull of environmental law. While I will introduce our expert moderator briefly, full speaker bios of all of our panelists are posted on our website, eli.org, and I would encourage you to check out their expertise in more detail there. Following each panelist's presentation, we will then move on to an open discussion and a question and answer session. You can submit your questions through GoTo's question box, and please do not wait until the end. Send your questions as soon as you think of them. It is my enormous pleasure to introduce our expert moderator for the session, Marna McDermott. Marna is Assistant General Counsel for Environmental Policy at Exelon, the nation's largest producer of carbon-free electricity. Marna has extensive experience in environmental, natural resource, and administrative law. Prior to joining Exelon, Marna was Deputy Director of the Conservation Litigation Project, which she helped launch in 2017 to support litigation in defense of public lands. Marna's 13 years with the federal government included serving as Deputy General Counsel for the White House Council on Environmental Quality and in several roles at the U.S. Environmental Protection Agency's Office of General Counsel. We are so thrilled to have her moderating the session today. And with that, Marna, I'll turn things over to you. The floor is all yours. Thank you, and I hope everyone enjoys this session.
Great, thank you, Nina. Can everyone hear me okay? Thanks to ELI for having us here today, and thank you very much.
Marna has frozen up for a moment. I don't know if you can hear Marna.
Hello, this is Nina speaking. Marna, if you can hear us, if you could please say so. All right, we'll wait just one more moment for Marna to rejoin. Thank you for all of your patience. Hello, everyone. I think Marna is having some technical difficulties, so I'll just give a very brief introduction, and when she's able to come back and join us, she can share some of her perspective. But as I mentioned earlier, today we'll be going over NEPA, ESA, and the fundamentals of environmental law. Marna is meant to do our introduction, which when she is able to rejoin us, hopefully. Also, Marna, I'm not sure if you can hear us, but when you are able to rejoin, we can go back and make sure that you get to introduce part of the topic. But today we have two expert moderators. We have Jim McElfish, who's with ELI, and Brian Williamson, who's at Akin and Gump LLP, to introduce the Endangered Species Act. And then, as mentioned, after these two presentations, which will go very into detail into both of these incredibly important statutes, we'll then transition into questions. So here Marna has an overview of many of the key statutes of environmental law, which I'm sure she'll be able to express in more detail a bit later. Then the importance of the Environmental Policy Act, which Jim will speak about shortly. The Endangered Species Act. Kind of the relevance of these statutes in everyday cases that you might have heard recently. So for example, the Keystone XL project, which was recently abandoned by the project developer. And here we have today's speakers. So with that, I will pass things over to Jim McElfish, who is the Director of Sustainable Use of Land Program and a Senior Attorney here at the Environmental Law Institute. and has many decades of experience with NEPA, and we're so thrilled to have him today as our expert faculty to introduce the National Environmental Policy Act. And with that, Jim, I'll turn things over to you. Thank you.
Okay, thanks. And I hope we can have Marna rejoin us soon. She could easily have done either of these statutes, and her expertise on NEPA as well as ESA is profound. So I'm Jim McElfish. I'm a senior attorney at ELI. I started my career many years ago at the Department of Interior, and one of my assignments at that point was to work on the National Park Service's version of the NEPA regulations, and we'll talk a little bit about agency regulations under NEPA, sometimes called NEPA procedures. From there, I was in private practice in DC for a number of years, and I've been with the Environmental Law Institute now for almost 35 years. So, National Environmental Policy Act, it's the first of the modern era environmental laws. It was enacted more than 50 years ago, but unlike many of our statutes, it was written in plain English, and it's only 4 pages long. So I commend it to you for your reading pleasure. The National Environmental Policy Act was signed into law by President Nixon on the 1st of January 1970. It was a bipartisan law, as many of the environmental laws of that era were. And at the time NEPA was enacted, there was no Environmental Protection Agency. There was no RCRA. There were rudimentary Clean Water Act and Clean Air Acts. But NEPA really was the first out of the box statute for the 1970s. It's important to pay attention to the NEPA regulations because the regulations have given much of the content to what we think of as NEPA practice. When you get to file public comments, what is an environmental impact statement, what alternatives need to be reviewed, and the like. These are largely explained in a set of regulations that were adopted in 1978. And interestingly, the regulations were at that time vetted by all the environmental groups at the time, the National Association of Manufacturers. Everybody liked them. Nobody sued, and they set the ground rules for the next 42 years of NEPA. Part of the reason for their general acceptance was they were, for the most part, based on the case law and NEPA guidelines that had been in effect between 1970 and 1978. So, in effect, we've had up until this last year, a fairly unbroken string of NEPA practice and what NEPA is about. So that while controversies arise over NEPA and regulations and particular projects, how the game is played has been pretty well understood for this long period of time. I mention this in some detail because the Trump administration in its last year adopted a wholesale rewrite of the NEPA regulations, and I'll touch on at least some of the aspects of those regulations. One of the things that they did was they indicated that the new regulations would be effective last fall, and the federal agencies have to come into conformance by this fall, I guess, unless the Biden administration makes changes, which we're expecting to do. Legislative context, this is the first statute in the environmental decade of the 70s. Clean Air Act was later that year. Clean Water Act 1972 passed over President Nixon's veto. Endangered Species Act 1973. So the statutes we're talking about today go way back in the modern era, and I've listed some of the others that I know Marna was going to talk about as well. Background rationale for NEPA was explained by one of its lead co-sponsors, Senator Henry Scoop Jackson of the state of Washington, he basically said our present knowledge, policies, institutions of the 1960s are not adequate to deal with what was understood to be growing environmental problems and crisis. And so that it was important to design and implement a national policy which, and the words are important, enable us to weigh alternatives. So whatever the federal government thinks is best isn't necessarily best. And Nepa for the first time said, you have to look at alternatives in a public way, and then to anticipate the undesirable side effects, which often result. So what does Nepa do? Nepa basically declares a national policy. Many lawyers overlook this because the courts have been more interested in the procedures. And basically said the policy parts of the statute aren't things that the courts will get involved with, but the policy is nonetheless important from an administrative law point of view. Second, it establishes an action forcing mechanism to ensure federal agencies consider alternatives and impacts. The action forcing mechanism is the environmental impact statement and its close relative, the environmental assessment. Provides for public accountability, public participation, created the Council on Environmental Quality, which originally was a council. It was a group of appointed officials, and it was modeled on the Council of Economic Advisors. The idea that Scoop Jackson had in mind was we have a Council of Economic Advisors, which is providing input on economic policies and telling us how the economy is doing and what happens. We need one of these for the environment. Later on, the presidents found the council format unwieldy, and so they have gone to a single member, single chair acting for the council. So it's been a one-member council for the last 3 decades. It also, NEPA required an annual report on the status of the environment. How are we doing? In 1995, the Congress abolished the requirement of the annual report to Congress, although interestingly, it didn't abolish the requirement of the report by the council to the president, which I've always argued could still be done and should still be done. Maybe we don't need an annual report since we can do things in real time, but that's the basis of what NEPA set out to do. So what does it direct? Here's the policy provision. Congress authorizes and directs to the fullest extent possible policies, regs, and public laws of the U.S. shall be interpreted and administered in accordance with the policies set forth in this act. This is essentially a rule of statutory construction, and it is a direction to the agencies and other administrators that they interpret their own authorities in ways consistent with the act. And there's a list of policies, and the courts have said we're not going to enforce the policies, but if you look at them, they look at what we later came to see as sustainable development. There's a policy of the responsibility of each generation to the succeeding generations. Intergenerational equity, it's right there in NEPA. So if you read section 102.1, every agency to the fullest extent possible should interpret and administer its laws to deal with things like climate change responsibility to the next generation. Section 102.2, and this is where the courts and agencies have been most deeply involved, and the regulations speak to agencies of the federal government shall include in every recommendation for or report for legislation and other major federal actions significantly affecting the quality of the human environment a detailed statement. The detailed statement is what we now know as the Environmental Impact Statement, or EIS. And the statute says statement is on the impacts of the proposed action adverse effects that cannot be avoided. So if you go ahead with it, what else do we need to think about or mitigate? Alternatives. So you can't say, here's what we intend to do, and here are the adverse impacts. Good to know. NEPA says you have to look at alternatives and evaluate alternatives. In a lot of the world, NEPA has been imitated by other countries. Environmental impact assessment has been adopted by hundreds of countries. Not all of them include the requirement to assess alternatives. Many of them are, here's what we propose, and here are the effects and how we're going to mitigate it. And these other things. I also list subsection E because the courts have said that the alternatives provision of subsection E is also judicially enforceable. So as well as C being enforceable due to the detailed statement, E is also enforceable even if you're not doing a detailed statement, you're doing an environmental assessment. That requirement applies. Agency role. So NEPA is not a centrally administered statute. It directly applies to every federal agency. So every agency has the obligation to prepare an EIS, or as we'll see, an EA or other documents, and to evaluate alternatives. So it applies to the Park Service or the Federal Energy Regulatory Commission or the Nuclear Regulatory Commission. Each agency has to apply NEPA directly. CEQ is tasked later on by President Carter with putting out regulations under executive order. CEQ also reviews and approves the agency's own NEPA procedures. So each agency will say, here's how we're going to administer NEPA in connection with our own review processes or planning processes. And those regulations are reviewed by CEQ to ensure that they're consistent with the statute and with the regs. And CEQ also has a dispute resolution function. EPA, under a provision that was added when the Clean Air Act was adopted later in 1970, EPA was given the task of reviewing EISs and commenting on how good they were at evaluating environmental concerns or dealing with mitigation effects or lack thereof. The courts have been central to NEPA. They enforce agency compliance. NEPA itself doesn't contain a citizen suit or enforcement provision, but the courts use the Administrative Procedure Act. And so the Administrative Procedure Act allows courts to review final agency action to ensure that those final agency actions are not arbitrary and capricious and are otherwise in accordance with law. So federal courts will review agencies' compliance with the NEPA procedural requirements. The federal courts under Supreme Court direction said, we're not going to look at agency substantive compliance, that is whether they've carried out the environmental policies of the Act. We're just going to look at, did they do a detailed statement? Does it consider all appropriate alternatives and the like? The federal courts in the 70s said the agency's duty is to take a hard look. The Supreme Court in the 70s in dicta said the hard look is what the agencies will do. They've never actually, the Supreme Court has never actually embraced the hard look doctrine in a binding decision, but they've certainly referred to it that way in the 70s. And the court says NEPA doesn't require a particular outcome, but does not bar unwise decisions, only uninformed decisions. And I've listed here a number of key Supreme Court decisions. Kleppe versus Sierra Club. There was a case basically dealing with federal coal leasing. We still have the same disputes all these years later. And the question was the federal coal leasing program an actual agency, final agency action or proposal for action? The court said it was not. But the court did refer to the hard look that is required when an agency does apply NEPA. Vermont Yankee and Strikers Bay are the decisions which said essentially the court's only interest is enforcing the procedural requirements, not the substantive outcomes of the decisions. Andrus versus Sierra Club basically is why the CEQ regs have been so influential. The court said those regs that were promulgated by the expert agency and relatively contemporaneous with, I mean, it was 8 years after NEPA had been enacted, but essentially it laid out the approach that has guided us ever since. This was before the later decisions on agency deference, but this one says at least the 78 regs get and have received substantial deference. Robertson versus Metho Valley dealt with mitigation, and if we have time, we can get into that. I talked about the regulations. Most of what we think of as NEPA requirements is actually in the regulations. Scoping of what's covered in the environmental impact assessment, public participation, what kinds of impacts are looked at, and the like. I'm going to turn it back to Marna as soon as I'm done, I hope. Glad you rejoined us. The CEQ regulations set out three kinds.
I apologize for technical difficulties.
We are pleased that you're back. The regulations set out essentially three key types of NEPA documents when there is a federal action. If you have a major federal action with a significant impact on the environment, or that might have a significant impact on the environment, you do an EIS. That's a detailed statement. You do scoping, which is a meeting or other procedure where members of the public can say, I'd like you to consider my 3 interesting alternatives to this proposed action. Or don't forget the subsistence fishermen. You may think of this as a road project, but we want you to study the impacts on fisheries or other things you might otherwise not consider. So EIS, you do a draft, public comment, and a final, and it leads to a record of decision. If you don't know whether you need to do an EIS, the regs say you do an environmental assessment. Environmental assessment has also become the preferred approach where if you can mitigate the action below the level of significance, you can still look at alternatives and impacts, but essentially you prepare an EA, which leads to a finding of no significant impact, so you don't need an EIS, and then the decision is based on the disclosures that are in EA. EA can have public comment, many of them do. It's supposed to be a succinct, concise public document. I have seen, unfortunately, EAs that run hundreds of pages, as some agencies, for whatever reason, would rather do EAs than EISs. And then the categorical exclusion is basically a set of actions that an agency, based on its experience, has said, this normally doesn't result in significant impact, and so we can determine that as a matter of rule. You can't do that ad hoc. You have to adopt a categorical exclusion in your NEPA regs, and then CEQ has to bless it in order for you to rely on categorical exclusions. Congress can also create categorical exclusions. The elements I've referred to scoping, it's required for an EIS. It's often used for environmental assessment. I have seen, not a great many times, but I've seen instances where an alternative identified during scoping actually became the agency's preferred alternative and was selected as the final. So my view of NEPA, in effect, is it's the one environmental law that doesn't treat the government as smarter than the public. Essentially, it says the public knows things we may need to know. So we're going to go out to the public with what we think our preferred action is, and we're going to ask, are there alternatives? Are there impacts? Are there mitigation measures? And NEPA provides the opportunity to figure out what those might be. Public participation, this is also key in US practice. The agency can't say thank you for your comment, goodbye. The agency has to deal with every substantive comment in a substantive way. Agency can group the responses to comments, but it can't blow off the comments. Otherwise, it's arbitrary and capricious, and the agency decision is then subject to being enjoined, or at least enjoined or delayed while the agency goes back and properly completes its NEPA obligations. Mitigation, it has to be identified in the EISs. As the Methow Valley decision says, you don't necessarily have to go into great detail, and NEPA doesn't require you actually to carry out the mitigation, because the Supreme Court has said it's an informational statute. Interestingly, though, if mitigation is used in an environmental assessment to bring an action below the level of significance, so you don't need to do EIS, arguably, if you don't identify and do that mitigation, your action is an action that has a major federal action with a significant impact. So arguably, maybe you need to do an EIS because your action is no longer that described in the EA. It's an issue which is still a live issue, but mitigation is important at each level. Key NEPA issues that have arisen over the years that are important. The NEPA regs we've been operating under until last year, you have to identify the cumulative impacts of the action and all reasonably foreseeable actions. So each action is not in its own box. If you're constructing a pipeline which runs through an urban neighborhood which has already got lots of sources of air pollution, and whatever cumulative impacts requires you to look at the impacts not only of that pipeline, but its contribution cumulatively to all these other impacts. And indirect impacts. Indirect impacts include things like induced growth, a highway interchange. You can't say, well, I'm just looking at the land occupied by the highway interchange. I need to look at the likelihood that development will occur around the interchange. The Trump administration rewrite of the NEPA regulations eliminated all references to cumulative impacts and indirect impacts. So does that do away with these obligations, or does the statutory requirement in NEPA and the court decisions over the last 50 years actually require us still to do cumulative and indirect impacts? I think it does, but it's obviously created a litigation issue for people. Alternatives, the regulations say you consider all reasonable alternatives, including those that are not within the authority of the lead agency. The new regs say if it's outside the authority of the lead agency, you don't have to look at it. In fact, you shouldn't look at it. So this would be a big change in practice if those regs hold. Categorical exclusions are used more and more. A lot of agencies are adopting them. New regulations allow agencies to borrow or adopt other agencies' categorical exclusions. So I think we'll see proliferation. And I expect, based on prior trends, we're going to see a lot more categorical exclusions even under this administration. Environmental justice is important. As I mentioned, cumulative impacts is basically a way of understanding environmental justice, impacts on minority and low-income communities. The entire edifice of environmental justice practice at the federal level based on the Environmental Justice Executive Order from the early 1990s is based on NEPA. And the guidance document is based on a CEQ guidance document on doing environmental justice, referring to all the requirements of NEPA and the NEPA regulations. Well, most of those requirements were swept away by the Trump administration rule last year. So what happens to all of EJ practice? It's not going away, but its underpinnings have been to a large extent undermined by the regulatory action last year. And climate change, of course, climate change is one of those impacts that can be looked at in multiple dimensions. And there's been a long struggle over to what extent emissions or induced emissions need to be looked at, and to what extent does climate analysis have to take place in EISs and EAs. And we're seeing again a reversal of where the last administration was going, which reversed where the Obama administration was going. But NEPA, as you saw from the statute excerpts, I think makes it clear that the agencies need to look at these impacts, which are among the irreversible impacts that occur from final agency actions. So the new NEPA rule applies to any agency action commenced after September 14th, 2020. That should be 2020. Apologize for that error. So if your NEPA process began last summer, a year ago, started then, you're under the old reg. But if you started after September 14th of last year, you are under the new reg. And the Trump administration reg expressly preempted all the agency existing regs and guidance documents and manuals, all of which were based on the regs we've been using for the last 40 years. And it preempted them immediately as of the 14th of last year, but it requires agencies to update their regs by this fall. We'll see what happens. The reg, as I mentioned, eliminated consideration of cumulative impacts, indirect impacts, alternatives and impacts not within the jurisdiction of the lead agency, got rid of definitions, and it, in effect, attempted to overrule some longstanding federal court decisions, and we'll see how that works out. There were 4 direct challenges to the regulations filed in federal court. They're kind of pending their way through, and the current administration is like, please give us more time, courts, because we're going to undo some of this, but we haven't figured out how much we're going to undo. And some courts have been fine with that, and other courts are like, don't mess around with us. We're federal courts, and tell us what you're going to do, or we're just going to decide the case. So that's where we stand, and I'm going to turn it back over to Marna to either introduce the whole program or Brian or both.
All right, well, thank you. I apologize for the technical difficulties. I also apologize if you could hear the swearing. I'm not sure if that was before or after I lost my volume, but I think I'm back. So I don't know if Jim got a proper introduction, but now everyone knows how great Jim is. So I will just briefly say thank you, Jim. He's a senior attorney at the Environmental Law Institute. He is director of ELI's Sustainable Use of Land program, which is a program that focuses on how the laws, incent proper human behavior in the use of land, which I think is a really worthwhile project. And Jim is an expert in many areas, and as you know, NEPA is one of them most relevantly. So thank you, and thank you for jumping in there when I got kicked off by the internet gremlins. So I am going to just briefly, Well, my advanced slide button is working. I'm just going to briefly go over sort of the landscape of environmental law and talk a little bit about sort of the different areas of environmental law. I understand this is the first of the substantive sessions of summer school. So I'm hoping that this is kind of a helpful framing for folks. I'm going to start with these circles down at the bottom of the slide. So people talk about environmental law sort of generally and broadly. In my view, there are several different, very interconnected areas within environmental law. Perhaps kind of the most classic environmental law area is the health and pollution circle you see there. So that might be a lot of the regulations that EPA does, for example, setting national ambient air quality standards under the Clean Air Act, which is a health-based standard. Then you have this green circle. That's going to be a lot of what the Department of Interior does. It houses, I think for the most part, the Endangered Species Act. It is, for example, where you would find the Migratory Bird Treaty Act implementation, which has been in the papers a bit recently. It is the Habitat and Critters bucket, as well as sort of the lands, the parks. And it overlaps with the energy bucket significantly because on our lands we produce a lot of energy. Now the energy bucket is my current focus and my current favorite bucket. It has started to kind of grow tendrils as climate change has become a leading issue in all these circles. And so energy is really kind of interwoven with all of these at this point. It's always been interwoven with the other circles to some degree because, of course, you know, we extract energy from our public lands. Energy production emits pollution that can be hazardous to our health. And there are many, many laws and regulations that go to energy. But I think even more, it is now integrated into this kind of environmental law world, whereas it used to be, you know, maybe the Federal Energy Regulatory Commission, or FERC, was like its own separate practice. Increasingly, environmental lawyers are wanting to kind of understand that world a little more. And then what is potentially one of the most important buckets and hardest to name is my blue one at the bottom here, the good government bucket. I was tempted to put the word process in there, but I think that doesn't give it adequate import because I understand most people would put NEPA into that blue sphere at the bottom. And I know, you know, Jim has just explained to us NEPA, so you all understand that, you know, the courts have said that NEPA is indeed an information statute and not one that drives outcomes. There are other statutes that really are formative in environmental law that I think go into the good government bucket, like the Administrative Procedure Act. You know, if you are launching a career in environmental law, learning the APA is always a good place to start. So there are a lot of sort of process requirements that really affect all the more substantive requirements and really can't be separated. I mean, interestingly, Jim mentioned environmental justice, and I think environmental justice up to this point has mostly made progress through using these sort of process-focused, process-oriented requirements like NEPA. I will just flag we do not yet have a substantive federal environmental justice statute. That is a big gaping hole in our federal environmental sort of law landscape, and it, you know, isn't here to talk about in this long list of environmental statutes that take up the rest of the slide. I recognize that you probably can't read the name of all these statutes, at least not without giving yourself a headache, but I wanted to include them here to give a sense of time as well as sort of substantive landscape. We have at the left-hand column what I think of as the range of kind of classic environmental statutes. Many of them fall more squarely into the health and pollution bucket. Folks think of the 1970s as the decade that we really got our environmental statutes. Congress was extremely active. The National Environmental Policy Act was let's see, I think it was signed into law on New Year's Day of 1970. Yep, getting the nod from Jim. So, you know, that got through Congress before the end of 1969 and kicked the decade off. You'll see I put, you know, 1980, 1990, 2000 in red there. That first section is by far the longest, and it really contains a lot of the formative laws that you'll learn about, you know, this summer if you're doing ELI's whole series of these. You can see the Endangered Species Act there, circled in green. It's in 1973. And if you work your way down toward the bottom, you know, the only one I've listed here after 2010, which, you know, some could dispute, that there are important things missing, but really the TSCA chemical safety rewrite is one of the few big flagship legislative efforts that has happened, you know, in the last decade. And so what we're working with in the sort of EPA health and pollution space is really a series of statutes that are showing their age a little bit. And to some degree, much of the progress has happened through both regulation and litigation. And I'm sure that came out through what Jim was describing, will come out through Brian's talk too. You know, the way we're kind of shaping and learning about what these statutes really require is not always looking to the statute itself, but looking to the court-made and agency-made law that has followed the statute, especially in Nepa, where you have such a lean statutory text to begin with. But before I leave this slide, I want to draw your eyes to the shorter list at the top above the circles, because it starts in the year of 1849 when the Department of Interior was established. So I just want to put in perspective that environmental law, as we think of classic environmental law, is indeed kind of a young area of law. You know, we're still using the 1872 General Mining Law. DOI is still operating with that as the operative law. I think Ulysses S. Grant signed that one into law. So, you know, 100 years before the Endangered Species Act. And a lot of the acts on the land side are older, are still in effect. You know, the 1906 Antiquities Act hasn't changed. If you're reading your E&E or your other trade press, you may have seen that the Secretary of Interior has just recommended to President Biden to expand or realize national monuments that were established under the Antiquities Act and shrunk under the previous administration. So there's still very much activity happening in these very old laws in the natural resource area. So I won't really spend much time on this slide because Jim already talked about NEPA. I did catch his piece of the conversation about cumulative impacts. So I do want to just pause on that because I find cumulative impacts to be such a fascinating area in NEPA practice. So cumulative impacts, that word I think was invented, and Jim will make a face if I'm wrong, through the regulatory process in the 1970s. The word cumulative impacts was put into the reg. He's making a face, so I might be wrong. Our court might have said it first. You want to jump in and correct me, Jim?
It was in the guidelines, but the Second Circuit did sort of put it in place really early in the 70s. So I'll give you that one.
Okay, thank you. And it really has been a point of inflection when you look at how the various administrations have tried to grapple with some of the harder environmental problems under NEPA. Because if you scope your NEPA analysis narrowly enough, you can always find no impact. But the more you have within your analysis, the more complex it becomes. So I just included a quote here from the Trump era discussion of cumulative impacts. And, you know, they had proposed, I think, some language that they got quite a lot of feedback on. Basically, they said CEQ is going to clarify that agencies should not consider effects significant if they are remote in time, geographically remote, or the result of a lengthy causal chain. Well, that's climate change. And I think they got quite a lot of feedback that that was not a good way to approach it without a little more nuance. So they added the word generally. So, you know, if you've worked for the government, I'm sure you can find a little humor in that. Whoops, we zipped past the Endangered Species Act. So, you know, the Endangered Species Act, as I said, in 1973 was signed into law again by Nixon, who also signed in to law Nepa. And I just like this quote from the signing statement, which I think sounds so idealistic and positive and forward-looking. Nothing is more priceless and more worthy of preservation than the rich array of animal life with which our country has been blessed. I think there was some pretty widespread agreement that the ESA was needed at that time. It has been so far much more complicated to make the ESA work than you might take away from that quote. So Brian's going to tell us a lot about, you know, the actual requirements and some of the nuances. But I did pull this quote from E&E at the bottom of the page that gives you a sense of folks who have been covering the ESA developments over the years, call it a forever war. So implementation of the ESA, figuring out what it means and making it work has, I think, continued to be really challenging. And this is my last slide before I introduce Brian. I just wanted to share an example. Specifically, the Keystone XL pipeline, which I know folks have read, has now been shelved by the developer, probably due in part to the many, many challenges. But I wanted to tell one story about one particular case, not that I was involved in, but I just found the progression to be really interesting and telling about the power of both ESA and NEPA. So last spring, 2020, right when the whole world was going absolutely crazy, a district judge, a federal district judge in Montana, issued an opinion in a case that had been brought to challenge the Keystone XL pipeline. And it was brought by a coalition of environmental groups and had several different claims in the complaint. And many of them were NEPA or ESA claims. And the claims went to, in part, a permit, the nationwide permit from the Army Corps of Engineers that the Keystone XL pipeline had relied on for part of one of its water crossings, and maybe many of its water crossings. But it was one permit for a project that, of course, required many, many permits. And the arguments were that the NEPA analysis hadn't been done correctly, and that an ESA consultation for this general permit had not been done when it should have been done. I'm oversimplifying, and you know, Brian can fix this later for me, I'm sure. But the idea was behind this case, the theme, I think, the drive was to really stop the pipeline, but by attacking this sort of general permit that the pipeline had relied upon and doing so effectively, the result was the judge held that the permit itself was vacated, was done incorrectly, inconsistent with the Endangered Species Act. That was what the judge looked to first. He didn't get to the NEPA claim in that case. And so the permit itself needed to be vacated, which caused quite a big uproar throughout the private sector because many, many people, companies, projects had relied upon this nationwide permit 12 to do, you know, linear projects. It was a pipeline that was being really discussed in the case, but it was the same permit that was used for like transmission projects or other linear projects if they, you know, fell under certain thresholds. Even the plaintiffs, I think, kind of eased off the breadth of their claim a bit because, they were focused on the pipeline, and the amount of uproar over, collateral damage was, causing some distress. Ultimately, through both the district judge reconsidering his decision and the appeal, it did get narrowed down to just affect the pipeline, and the rest of the permitted projects were able to continue. And then the last administration actually amended those permits, and there are several threads going on now, but it is no longer operative in terms of affecting projects at the moment. But you can see the power of Nepa and ESA to undermine that process, or to appropriately stop it, depending on your view. So that is all my substance to share with you today. I apologize for having to be out of order, and I'm very grateful for your patience. I will go ahead and introduce Brian now, because he is going to speak about the Endangered Species Act, which is a great introduction to the habitat and critters. Habitat being, I think, a really interesting issue right now, among other things. So Brian is an associate with Aiken Gump. His practice is in environmental and natural resource law. He works with clients on a range of matters: litigation, regulatory, and transactional. Brian graduated from the University of Pennsylvania Law School, where he was on the editorial team for the Regulatory Review, as well as the Journal of Law and Social Change. And Brian also has some government experience, having worked at EPA Region 3, I think, during law school. So thank you, Brian. I will hand control over to you.
All right. Thank you, Marna and Jim. Can everyone hear me okay? All right, perfect. And if that changes, let me know, as I'm sure everyone has experienced. The Zoom world can sometimes be crazy sometimes, and my computer has been no exception over the last 15 months or so. But I am delighted to be here today with everyone. I, like many of you in the audience, was an ELI summer school student myself a number of years ago, before my hairline started to recede. But I am really happy to just be here to give you guys an overview of the ESA. I know that you will be hearing a lot of information. You've already heard a lot from Jim, a lot of really good information. I hope to give you at least 10% as good information as Jim gave you today. So that's my goal, and I'll know that I'll do my job if you walk away with at least hopefully 5 or so takeaways from today's session. So I just wanted to start at a 10,000 foot, really high level on what is the ESA. And unlike Nepa, where the name can leave a lot of questions in your mind, like what does the National Environmental Policy Act actually mean? The ESA's name actually does a fairly good job telling people what it does. And its goal is to make sure that plant and animal species don't go extinct due to human activities. And more specifically, the ESA has 3 primary purposes. It aims to provide a means whereby the land or water resources upon which endangered species and threatened species depend may be conserved. It also tries to conserve those endangered and threatened species themselves, and it also tries to implement various international treaties, agreements, and other congressional findings that led to the promulgation of the Endangered Species Act back in the 70s, as Marna let us know. But at a practical level, what does that mean? On this slide, I have 6 pictures of beautiful little critters and animals, and the goal at a high level is to prevent what happened to the species on the left from happening to the species on the right. So the species on the left are the black rhinoceros, the bramble K malomus, and the Xerces blue. Those species are either extinct or about to go extinct. There's always, I think, some question when you try to figure out if a species is extinct, because some scientists might say, no, there might actually be one over here on Madagascar who hasn't died out yet. But for all intents and purposes, unfortunately, we lost or are soon to lose those species on the left. But the goal of the ESA is to stop that from happening to those species on the right, which are the sage grouse, the red wolf, and the Florida manatee. And hopefully today you'll have a better understanding of how the ESA is trying to do that. So I will try to cover a lot of ground in not a lot of time. When Jim, Martin, and I were discussing a few weeks ago this presentation, I was very ambitious, as I always am when it comes to trying to nerd out over environmental law. But unfortunately, I am going to have to go pretty fast, and I might not be able to get into as much detail as I would like to, but there is thankfully a wealth of information out there. I highly recommend the U.S. Fish and Wildlife Services website, NOAA Fisheries website, and there are plenty of great treatises. So if you ever have some downtime this summer and you want to learn more, definitely check out the wealth of information that's out there. But my goal is to give you an overview of the Act, then an overview of a few of the most important sections of the Act that you're most likely to hear about in the future. I will briefly touch on the implementing regulations, some of the recent changes we saw under the Trump administration, and then some of the changes to those changes that we currently are seeing under the Biden administration. And then lastly, I'll touch briefly on some of the landmark litigation, a great case from the early days of the ESA, a few more recent cases, and then I'll talk about some of the hotter topics that are in the news today. So on this slide, I am trying to now take it from a 10,000 foot level to probably like a 1 to 5,000 foot level overview of the ESA. So as Martin described earlier, Congress enacted the ESA, the height of the mid-century environmental movement, when many of the country's plants and animals were becoming or in danger of becoming extinct. So who or what does the ESA protect? It seeks to protect imperiled species and ecosystems that they rely on to survive. This includes all species of plants and animals with the exception of pest insects. So for those living in DC or Philadelphia, two places where I've lived, and you have giant cockroaches trying to get into your apartment, the ESA won't protect them. You can go ahead, you can kill them if that is your thing. I've certainly killed many in my life. The only animal that I've directly killed, I think, except for spiders. But more importantly than that, we'll get into exactly the nuance of how species get protected, but who's responsible for implementing the ESA. So we have the U.S. Department of the Interior and the U.S. Department of Commerce. Under the U.S. Department of the Interior, we have the Fish and Wildlife Service, which bears responsibility for protecting terrestrial and freshwater organisms. And then under the Commerce Department, we have the National Oceanic and Atmospheric Administration, or NOAA. And under NOAA's umbrella, we have the National Marine Fisheries Service, which is NMFS, or NOAA Fisheries, as most practitioners probably refer to it. You might be wondering why we don't just have these all under the Department of the Interior, or why don't we just have one agency that is charged with protecting species. And I should also say that NOAA Fisheries is in charge of protecting marine wildlife and anadromous fish, which are those fish that migrate up rivers from the sea to spawn, like salmon. And the reason why NOAA Fisheries is within Commerce and not under Department of the Interior is apparently because, as we know from earlier, President Nixon signed the ESA into law, and he was in charge with being the first administration to implement it. And he didn't like the Secretary of the Interior, apparently because he criticized Nixon's stance on the Vietnam War. So Nixon, apparently out of anger, wanted to punish the secretary by putting NOAA within the Commerce Department, whose goal was generally to create conditions for economic growth. I actually did not know that, but until recently when I looked that up, but I always did wonder. So hopefully, if you guys are wondering the same thing, you'll now know why. And then I just wanted to briefly touch on who or what the Endangered Species Act impacts. And it obviously impacts the species that are protected. It impacts species in other countries that might not exist in the United States. For example, the red kangaroo was listed as endangered in the United States back in the 70s. And that listing ended up preventing the import and trade of kangaroo products in the United States, which indirectly affected the market in Australia for the red kangaroo. And it led to the kangaroo eventually being protected, and scientists declared it recovered in 1995. And in terms of, I guess, less direct impacts, the Endangered Species Act impacts federal agencies and states. Many states choose to implement the Endangered Species Act in their own way through federal funding, they create their own programs to protect species, and federal agencies have to, as you learned from Nepa, be mindful of potential impacts on protected species when they are funding projects, initiating projects on their own accord, or issuing or granting permits. And then at a basic level, the ESA impacts landowners, it impacts project developers, it impacts anyone who wants to hunt. If you decide that you wanted to hunt an endangered species, that's prohibited, and you would not be allowed to do that, as Joe Exotic, aka Tiger King, learned earlier this year when he was imprisoned for 22 years, which we'll talk about a little bit later, because that's mind-boggling and fascinating to me. All right, so now let's dive into the section. So again, we can only cover a small snippet of the sections of the ESA in the time that we have today, but I did want to focus primarily on section 4, which is the section that governs the listing process. And I tried to segment section 4 into 4 questions. The last 2 actually relate more so to later sections that we'll talk about, but these were the questions that I had when I was first learning about the ESA, about the listing process. And you will see a complicated chart on the right. I don't know if you can actually see that on your screen, given how many steps there are, but you can easily find that online, and I'll walk through some of those steps briefly today. So the listing process begins with trying to understand what counts as a species. And as I discussed earlier, any plant or animal except pest insects are eligible to be listed under the ESA. This includes subspecies, varieties, and distinct population segments of vertebrates. And then to date, over 2,300 species around the world have been listed as endangered or threatened under the ESA, and about 70% of those exist in the United States. So now let's talk briefly about how species are listed. And the listing process can begin essentially in one of 2 ways. An agency like FWS or NOAA Fisheries decides that it wants to list a species and protect it, or a citizen or nonprofit group decides to petition the agencies to protect the species. And when the agencies are presented with determining whether a species warrants protection or not, they consider 5 factors based on their biological status and threats to their existence. And these include damage or destruction to species habitat, overutilization of the species for commercial, recreational, scientific, or educational purposes, disease or predation, the adequacy or lack thereof of existing protections, and other natural or man-made factors that affect the continued existence of the species. And agencies evaluate those 5 factors based on information from current scientific literature, federal and state resource agencies, universities, and essentially any commercial source. So anything that is scientifically defensible and reliable is fair game for the agencies to rely upon in making the listing determination. So the agencies then conduct an assessment to determine if there's sufficient information to support a listing, and then they will start the listing process. And for species that the agencies do determine warrant some degree of protection, but they might not be the highest priority species for whatever issue, for whatever reason. For example, if they are likely to become threatened or endangered, or maybe already actually are, although not legally, but they might not become imperiled for a long period of time, and there's species that might die out earlier. Those species that have a lower priority might be identified in a document called a candidate notice of review, which is published annually, and it essentially gives everyone some degree of notice of species that may end up becoming listed in the future. Sometimes those species do actually end up being protected through processes outside of the ESA, and they may never end up getting listed, but in many cases they do. And I also mentioned earlier that private citizens or organizations can also petition the agencies to protect a species, and that is the process laid out in this chart on the right. And it takes a period of time. It starts with 90 days after a petition is filed. The services have to respond to the petition, make a finding, and then from there carry out a more formal process through rulemaking and notice and comment to decide whether or not to list the species and protect it. All right, so that was a whirlwind of Section 4, and jumping into Section 7 now, we'll start to talk about how species are protected and what that means. And Section 7 is all about consultation. So as we learned about under Nepa, when federal agencies are making any major decision that could impact the environment or protected species, they need to consider potential impacts on protected species. So the ESA also has an explicit requirement for federal agencies to consider not just whether an action will affect a species itself, but also its critical habitat. And that is habitat that species rely on for their existence and well-being. And there has been some regulatory developments in how the word habitat and critical habitat has been interpreted under the ESA, under the Trump administration. And it looks like under the Biden administration, we may revert back to the pre-existing rules that were in place. But when it comes to Section 7, this typically requires federal agencies to consult with FWS or NOAA fisheries, and that process can be either informal or formal. Informal consultation requires agencies to quickly evaluate potential effects on listed species or their habitats, and it can be used to determine if a more formal, robust consultation and review of those potential impacts is necessary. And the trigger for informal consultation is whether an agency's decision, such as the issuance of a permit, may affect a listed species. So it doesn't have to definitely affect the species, but if it may affect, then we will have informal consultation. And throughout that process, agencies may prepare what's called a biological assessment, which is a document that summarizes the existing science and the literature and assesses whether a project such as the installation of a wind farm or the development of an area to put condos in or the establishment of a pipeline, if those are likely to affect a protected species, then we'll move to the formal consultation process. And that formal consultation process tends to take more time, and that process, again, involves more correspondence back and forth between the agencies, and oftentimes when we have private project developers who might need a permit to commence a project, they will also engage in that process as well. They'll be copied on emails, they'll be sending information about the project, and they'll have a lot of fairly robust back and forth with the agencies. And the formal consultation process results in what's called a biological opinion. And this is the document that officially determines whether or not a proposed action is likely to jeopardize the continued existence of a protected species or adversely modify its habitat. And that opinion might include what's called an incidental take statement, which we'll talk about briefly on a future slide. And that provides measures to protect species and to minimize impacts of a project or the federal agency action. And the last thing that I wanted to briefly touch on this slide was some lessons that I've learned in my practice. My practice at Gump has been primarily, in terms of my exposure to the ESA, has been more on the transactional side. So I've done a lot of diligence reviews on large projects where companies want to either purchase other companies or they want to install a project. I've done a lot of solar, wind work, some oil and gas and coal work as well. And what we've seen is these projects typically don't get completely held up or canceled from the Endangered Species Act. I think sometimes you can see in the news, for example, the Keystone XL pipeline, and a lot of people might think that that's a pretty common thing for these large projects to get canceled from the ESA. And at least in my experience, we see that project developers and agencies do really consider and they take seriously the ESA and potential impacts on protected species, but the most practical impact is probably some sort of delay or at least the need to start the consultation process early on in the life of a project and well before any transaction and any funding or money will be spent. The developer will reach out to the agencies, typically both state and the federal agencies, to determine what they need to do to make sure that they're minimizing impacts on species. And I think the species I've seen most common in my practice with the projects I've worked on tend to be the northern long-eared bat, which is all over the country, and it is a protected species. And a lot of times what we'll see is project areas being segmented or redesigned around critical habitat. So if there are a lot of trees where the solar panels want to be placed, the developer might have to, instead of using a square project area, they might have to morph it around the trees to minimize the clearing that would potentially impact that species. And we also see changes to project timing. For example, project developers might avoid clearing trees during the roosting season of the bat from June 1st through July 31st. So if anyone in this audience is about to install a giant solar field in your backyard, I would probably wait until at least August to do that, just so we don't hurt any of the bats. But from a practical level, again, the big takeaway is we usually don't see the ESA ruining or halting projects permanently, but most often we do have to redesign projects around potential impacts to species. And the earlier in the process that is started, the better. A lot of times projects get to my desk when I'm doing a diligence review for a company that's acquiring a project. Most of the work will be done. And there are instances where I've seen the project comes to my desk and we're reviewing it and the work is not done yet. And that's usually where we talk to the client and say, hey, the developer is really not that far along in the endangered species review process, which means that there could be delays. And if you are trying to fund the project by the end of next week, because for whatever reason, that's when the deal needs to get done, you might need to reconsider that or change the transactional documents to make sure that you are protected in the event of any delays. So moving on to sections 9 and 10 now, this is where the ESA talks about what you can and can't do and provides exceptions and permits for activities that might impact protected species. And here, the main, again, high-level takeaway is this applies to just about anyone subject to US jurisdiction. It applies to individuals like you and I who want to go in our backyard and knock a tree down. It applies to organizations, whether it's private companies who are planning projects, and it also applies to entities like federal and sometimes state agencies when they're acting as well. And the main prohibition is that it is unlawful to take endangered species or wildlife. And I remember when I first learned the ESA years ago, I thought take just meant going out and killing a species. And it turns out that the definition is much broader than that. It's not just killing an animal or a protected plant, but it is to harass, harm, pursue, hunt, shoot, wound, kill, trap, capture, collect, or attempt to engage in any such conduct. So again, very broad. Anything that, generally speaking, negatively impacts a protected species is probably prohibited from the ESA. And similarly, the word harm has been defined by regulation to include significant habitat modification or degradation, which actually kills or injures fish or wildlife by impairing behavioral patterns such as breeding, spawning, rearing, migrating, feeding, or sheltering. So again, the prohibition tends to be pretty large, and this can result from direct behavior that's aimed at species, or indirect behavior such as removing trees that a species relies on. And one other aside, you might be wondering if you find yourself, let's say you're up in the woods in Alaska and you come across a wolf that is sick, and you surprise it and the wolf tries to attack you. You might wonder, well, it's a protected species, so do I have to fall on my sword and get devoured by this wolf, or can I defend myself? And there is actually an exemption in the Act where if you in good faith believe that an animal is going to result in bodily harm, you can defend yourself against that species. I actually, I was in British Columbia a couple years ago before the pandemic, and I was trying to get to an Airbnb in the pitch dark late at night, and I did stumble across a wolf, and it was one of the craziest experiences of my life. I thought it was a deer at first, and I saw the long tail, and I saw how big it was. And I did what you shouldn't do, which is I turned around and ran and screamed like a child. And thankfully, the wolf didn't want anything to do with me. And I had no desire to ever harm a beautiful wolf. But the Endangered Species Act protections are really strong, and they are pretty far-reaching. So that's the main takeaway I wanted to hit on here. I also wanted to touch on briefly the distinction between protections for threatened species and endangered species. So endangered species are those who are actually at serious risk of going extinct, and threatened species are those that are reasonably foreseeable or likely to become endangered in the future. Threatened species historically have received the same protections as endangered species. The Trump administration did revise what's called the Section 4D rule that makes the default protections for threatened species the same as those for endangered species, but it's my understanding that the Biden administration is in the process of rescinding that rule, which means that the default of equal protection between threatened and endangered species in the future is likely to be back on the table. And I also wanted to talk about another exception to the general prohibition against taking protected species, and that's the incidental take permit. And this is how projects that, despite the best efforts by the developer, might still impact a protected species. So if you think of a pipeline that has been carefully redesigned around critical habitat, but might end up harming a protected turtle species, or a wind farm that has been carefully put in an area where there are a few protected bird species that fly there, those projects might still end up, unfortunately, harming a protected species despite best mitigation efforts to the contrary. And in those cases, developers and agencies can work together to obtain what's called an incidental take permit, which allows the take of a protected species if it's an incidental and not purposeful result of an otherwise lawful activity. So if the pipeline has been properly permitted and all mitigation measures provided in a habitat conservation plan are being followed, and it results in an unfortunate take of a species, the developer will not incur liability under the Endangered Species Act. And to approve the habitat conservation plan, the services must find that the applicant for the incidental take permit will monitor, minimize, and mitigate the impacts of any incidental taking of the listed species. So again, as I discussed earlier, that might involve timing your activities around critical roosting seasons, or changing the project design. And typically that involves a lot of planning and engaging scientists to conduct surveys, and just being really thoughtful throughout the project planning process to make sure that any impacts on species are minimized. And last but not least, I wanted to talk about Section 11, which contains penalties and enforcement. These are fairly straightforward. Civil penalties can range up to $25,000 per violation and more once we factor in inflation. And criminal penalties can include fines of up to $50,000 and a year in prison per violation. I of course, had to talk about Tiger King again, because that was my favorite show from the early pandemic days. When we were all watching Netflix, not sure if we were going to survive till the end of the year. And as you probably heard or learned from the show, Joe Exotic was convicted and sentenced to 22 years in prison on 9 counts of violating the Endangered Species Act by allegedly killing 5 tigers to make room for other big cats at his farm, and for selling and offering for sale tiger cubs in interstate commerce. Now, the prison sentence is, more than just 9 years for the 9 counts, but he also was convicted of murder for hire for Jane Doe, who I think we all know is Carol Baskin, and for falsifying wildlife records as well. And this chart on this page has nothing to do with penalties, but it does show that there has been less funding allocated towards enforcement of the Endangered Species Act over the last few years. Funding does remain fairly high, but there has been a slight dip over the last decade. And to fill that gap, we've seen private citizens launch citizen suits under the Endangered Species Act, where they give agencies 60 days notice where they intend to sue to stop an alleged violation of the act. that adversely affects the person suing. I will spend just probably 15 seconds on this page. If you're still hanging on at home by this point in the presentation, you might be wondering where the regs are. And these are the regs. So I think this presentation will be up online, and you can, again, probably find these in a treatise. But these are the implementing regulations of the Endangered Species Act that implement those sections that we talked about earlier. And now we'll dive briefly into some developments under the Trump and Biden administrations. So there were about 5 main rules that were the big ones that people think of that the Trump administration changed. And these rules related to listing species and designating critical habitat, the prohibitions to threaten wildlife and plants, which I talked about earlier under the so-called 4D rule, and the changes also revised many definitions that govern the process that agencies use to cooperate with one another, essentially allowing for expedited consultations under the Endangered Species Act. And the Biden administration has, as it has done with many environmental rules promulgated from the prior administration, it has announced that it will be reviewing many of those rules, including those 5 that I mentioned earlier. And those rules likely, once promulgated after a notice and comment process, will revert back to the status quo before the Trump changes. I did want to briefly touch on a few other actions that the Biden administration has indicated that it is taking or might take over the next few years. One is with wolves. As you may have seen in the news lately, wolves have recently been delisted, which has allowed people to hunt them again. And many wolves have been killed, particularly out in the Midwest and the West. And President Biden was recently asked by a kid, I think in like a YouTube interview, whether he'll protect the wolves. And apparently the president said that his grandchildren had asked him to protect the wolves. And he told this kid interviewing him to reach out to Secretary Holland to let her know that we need to protect the wolves. So that could be on the horizon. One thing that's definitely on the horizon are protections for the lesser prairie chicken. So we had a proposed rule last month that proposes to list the lesser prairie chicken as endangered because its habitat has shrunk by about 90%, apparently due to degraded and fragmented habitat in the Great Plains from commercial development, including oil and gas, agriculture, and of course, warming temperatures from climate change. So those protections, if they make it through in the final rule, might end up impacting many oil and gas projects out in Texas and New Mexico. But at the same time, there are protections for species. We will also potentially see some actions from this administration that might not go as far as environmentalists like. So for example, I listed polar bears and Pacific walrus on this slide, and because there was a proposal last week from the administration that will allow oil and gas companies in Alaska to, as long as they don't purposefully impact polar bears and walruses, to commence drilling and exploration projects that might have the potential to result in non-lethal incidental take, and that would not subject them to liability under the Endangered Species Act. And last but not least on this page, I did want to just flag for the audience something that I came across in my preparation for this presentation called the Bernhard memo, which was a memo from the George W. Bush administration that concluded that agencies do not necessarily need to consider the impacts of greenhouse gas emissions and climate change in their consultations under the Endangered Species Act. There's been a push for the Biden administration to rescind that memorandum and to start to consider the effects of projects, for example, approvals of or the promulgation of mobile source emission standards under the Clean Air Act. Some groups have hoped that the agencies EPA and NHTSA would consider the impacts on polar bears from climate change that could result from greenhouse gas emissions from cars. And so that's something that we could see on the horizon from this administration. And I know that I am getting very close on my time. So I wanted to just touch for a moment on some litigation. Probably the most important case that you will see in your studies of the Endangered Species Act is TVA v. Hill, which was a landmark case from the 70s that established the expansive reach of the Endangered Species Act. And in that case, essentially, there was a project to open up a federal dam that at that time it was believed would kill the snail darter, an endangered fish species. It turned out that the snail darter was actually not as endangered as people thought. It had other populations in other parts of the country, but that case went up to the Supreme Court, and the Supreme Court did actually uphold that, did halt that project, even though it a lot of money was already spent to push that forward. But after that, we saw Congress react by amending the ESA to incorporate a bit more flexibility for projects, and it also created what has become known as the God Squad, or the Endangered Species Act Committee, which consists of cabinet officials and others who can exempt federal agency actions that could result in takes to protected species. That has really been rarely used. I think only once or twice, I believe in the context of the northern spotted owl back in the 90s, but even that decision was tied up in the courts. There are a few other cases on this page that are pretty important. I think from a practical standpoint, I'll just briefly highlight the last one, Defenders of Wildlife versus Zinc, and that one was a case that just shows that federal agencies do receive a degree of deference as long as they don't act arbitrarily and capriciously under the Endangered Species Act when they're making decisions to list or delist species. But there's always a lot of litigation, and agencies usually win, but not always. And there's a few examples on this page where agencies have not conducted the required evaluation that courts have expected to see them do before they approve or take an action. And then lastly, as both Jim and Marna have highlighted, the Endangered Species Act does intersect with other environmental laws. We see it intersect with the issuance of permits under the Clean Water Act, for example, in the Keystone XL pipeline, when agencies allegedly did not adequately consider the impacts on protected species from issuing those permits. We've seen some very interesting litigation come out recently, I think mainly over the last year or so, under the Clean Air Act, where environmental groups are pushing for more stringent standards for air emissions of particulate matter and ozone, where the groups are arguing that EPA has failed to conduct a consultation with the services on the impacts of rules that restrict those emissions of air pollutants. So it remains to be seen where those will go. We have seen some success when environmental groups have challenged FDA reviews of genetically engineered animals, such as salmon, and it turns out that the FDA does need to consider, or at least environmental groups can challenge the failure to consider endangered species impacts of approvals related to genetically engineered animals. And then finally, as another big example that you may encounter in your practice one day, is that the EPA does need to consider impacts on protected species when registering pesticides. And we've seen a wave of litigation that has actually threatened the potential viability of a number of new pesticide products. So with there, I know that I covered a lot, and I hope that you guys took some useful information away from this presentation. I think I'll turn it back over to ELI to open this up for some questions.
Perfect. Thank you so much, everyone, for your excellent presentations. I know I certainly learned a lot, and I'm sure all of our participants did as well. And thank you to our participants for sending in so many excellent questions. We have about half an hour left, so we'll try to get through as many as possible. And so our first question is, why is NEPA referred to as the Magna Carta of environmental law?
I don't know who first coined that. I think Magna Carta is viewed or has been viewed in the English-speaking world as the first statement of procedural rights. So it's the rights of the barons to trial by jury of the peers, and that the king can't act arbitrarily to confiscate property and the like. And I think with NEPA being the first modern environmental statute out of the box and setting up procedural rights related to a public notice and comment, and to a government not acting arbitrarily in the environmental area, that people have blessed NEPA with the term Magna Carta. I don't tend to use it, but I'm too interested in medieval history, and I want to like untangle what the Magna Carta actually did.
Perfect. Thank you, Jim. Unless anyone else wants to add on to that, we'll go to our next question, just because I know we have many, and thank you again to the participants for sending them in. If you have more, please send them in as soon as possible so we make sure we get to them. So question number 2, for the public participation element of the EA and the EIS, who are the types of people and organizations that generally submit these comments? Are they academic, corporate, or just normal people?
So one of the great things about NEPA is that it actually does attract comments and involvement from organizations and people and governments across the spectrum. So sometimes you'll get 100,000 comments on something, most of which will be form comments. Don't approve this project, or please protect this beloved area from logging or whatever. But it doesn't matter if you are an individual, if you're submitting something of substance, you're suggesting an alternative that should be considered, and the agency fails to do so, your comment is just as important legally as the comment from the Giant Trade Association. The other thing that's worth noting is that local governments participate in submitting comments. Indian tribes, Native American groups, Alaska Native villages. There are these wonderful opportunities, and there actually is participation across the board. It is the most democratic small d of our statutes. And I'm going to hope that some of the ESA questions will be early, so it's not all NEPA and then ESA, but maybe.
Perfect, thank you. That's a great point, actually. We'll jump around so we'll get some ESA in the mix. So going on to an ESA question, perhaps for you, Brian, but also Marna and Jim, feel free to jump in. One participant asks, can states make their own laws that are stricter than the ESA? I think the participant specifically was curious about California's law to ban the sale of products containing exotic animal skins and furs, namely alligator and crocodile products, and the resulting regulations and Louisiana's response to sue California.
That's a great question, and I actually did have that in my notes, but I think I could only present on probably like 20% of what I actually wrote down. So I wrote down like probably 8 hours worth of content. But the short answer is yes, states can enact more restrictive or stringent regulations that go beyond what the federal rules and protections do require. Typically, the federal laws, and this does hold, I think, generally throughout federal law. I'm by no means a preemption expert, but in many cases, the federal rule might set a floor of the minimum level of protection needed, but states can always go more strict than what the federal government requires. So if the federal government decides not to protect alligators, there might not be a floor there, but if a state decides that an alligator within its borders is worthy of protection, then that state can list its own species as protected under its laws. I'm not too familiar with the Louisiana-California case. I've definitely heard about alligator products. I'm a big alligator fan myself. My parents recently moved to South Carolina, and I get like 20 Snapchats a day from my mom, who Snapchats more than I do, of all the alligators that she's seen. And I know that alligator products are huge, so that litigation is likely to be big. And I think that it's relatively recent, so it probably has not resolved yet. But the high-level takeaway is, yes, states can go beyond what the federal ESA protects.
Perfect. Thank you, Brian.
I don't know if Marna wanted to jump in, but there's an angle here too that I agree completely with Brian on the ability of states to regulate more strictly or stringently. There is this angle where if the state is regulating interstate commerce in a way in which Congress has occupied the field, or a doctrine called the Dormant Commerce Clause comes into effect, the state's ability to regulate trade is a little bit more constrained than its ability to protect its own species. So I just want to have a little footnote for this other set of non-environmental doctrines that might apply.
Yeah, that's a really interesting flag, Jim. So I think what Jim's talking about is the Dormant Commerce Clause, which basically says, and I'll oversimplify terribly, but like state A cannot discriminate against products in commerce from another state. And it's premised on pretty old case law that, looked at, for example, putting a tax on out-of-state milk to benefit in-state dairy farmers. That it is the flip side of the Commerce Clause. And there is right now, I think, before the Supreme Court, a petition for cert on a case that will be really interesting on this point. So the state of Washington denied a Clean Water Act permit for, I think it was an export facility, and the upstream states that were exporting coal to send to Asia from this export facility were left without an export facility that they were planning to use to sell their coal. And they are petitioning the Supreme Court, and Jim looks like he knows more about this than I do, but to take that as a Dormant Commerce Clause case. Now the facility, I think, is no longer in play, right? They withdrew that. So it's really a battle between the states. Washington says we're protecting the health of our citizens. And I think it's Wyoming is leading on the other side, is saying, you're making it so we can't sell our coal.
I was just going to shorten this up because it looks like we should have Dormant Commerce Clause as a subject in next summer school. But we'll go back to ESA and NEPA.
Perfect, thank you. And jumping around a bit, we now have a question for Marna, who mentioned environmental justice in her introduction. And one of our participants is wondering, with EJ having an upward moment, how soon may we expect a federal statute?
Well, now that is such a good question. I have that question too. I think where most of the action has been for several years has been in the state legislatures. So if you look around the country, I want to say more than half the states have something that is something like an environmental justice statute at this point. The sort of landmark one is New Jersey's from, I think, 2020, which is held up as a really good model for how you might do a federal EJ statute. So if you're curious to see what an EJ statute looks like in the program, New Jersey has their website up and running, and they've categorized by like zip code and census block, like demographic information. So they're really, I think, providing a model of what a federal EJ statute could look like. Several pieces of federal legislation have been introduced. My guess is that that is not imminent with the current political situation, just with the Congress being so divided I know that the focus is right now on infrastructure, and it seems that the focus on infrastructure and climate may bring some piece of environmental justice along, but I don't think a standalone environmental justice law is imminent, unfortunately.
Perfect. Thank you so much, Marna. Now jumping back to the ESA, this one I think is for Brian. Does the ESA include any follow-up requirements to check whether project adjustments were actually effective for protecting species?
That's another really good question, and the short answer is yes. So there is a process under the Endangered Species Act that allows species to become delisted. And I think I had mentioned very early on in the presentation that about 99% of species that have been protected under the Endangered Species Act have actually become successfully protected, and many of them have been even delisted too. So to date, 46 different species have been delisted because it was determined that the protections are no longer needed because the population has recovered to the extent that the species is no longer scientifically threatened or endangered, and the delisting process is handled under Section 4 of the Endangered Species Act. So that's definitely something that Congress accounted for, and in a perfect world we'll see many delistings because that would mean that our efforts to protect species have been successful.
Wonderful. Thank you so much, Brian. Now going on to our next question. I think this one is for Jim. How are cumulative impacts defined under Nepa? For example, if a drilling company puts in separate permits in the same area, are they analyzed all together?
They are analyzed all together. And cumulative impacts are the impacts of the current project, prior projects or activities, and all reasonably foreseeable activities. Now, the definition of cumulative impacts was in the regulations for 40 years, but was eliminated in the rewrite last year. So if you're currently doing you're a consultant preparing NEPA documents, or you're a project proponent or whatever, it's still wise to do these because something doesn't cease to be an environmental impact simply because the word cumulative was removed from the regulation. So I think it would behoove one to rely on the long-time understanding, which also appears in a lot of court decisions as well. But it's the underlying existing conditions plus the conditions created by the federal action or project, plus the impacts of reasonably foreseeable actions. And the idea is so that you don't, and the courts have said it's illegal to segment actions into little tiny actions. So I've got, one oil well here, and I've got another oil well 50 yards away. That's all one action. Cumulative impact sale. I also look at the fact that there's 17 oil leases surrounding this area, as well as 3 pipelines and a water treatment plant.
Perfect. Thank you, Jim. Thank you for clarifying that. Up next, we have quite a quick procedural question. As Marna was formerly an EPA attorney, I'll send this one over to you. And the question is, does EPA review all agencies' EISs or only EPA EISs?
So EPA does have a role, and I think Brian may actually know more about this, even though I was at EPA. EPA does have a role with respect to all EISs. It results in a giant amount of information coming through EPA, and EPA having the opportunity to process that. But I don't know that there is, I don't know, Brian, maybe you can help me out here.
Yeah, I do know that agencies have their own implementing regulations for how they will promulgate EISs. I've actually, even though I'm an environmental lawyer, I've practiced more on EISs in the FAA context than in the EPA context. So I'm not too familiar with the exact specifics of EPA's regulations, but agencies do generally do their own thing there. And it sounds like Jim, our resident.
So this one's actually relatively straightforward. EPA has an office located in headquarters called the Office of Federal Activities, and it is responsible for reviewing and coordinating the review of EISs prepared by other agencies like the FAA or Interior Department or whatever. And often the day-to-day or the detail is done, by the EPA regional office, where there's an activity. What it is an extra layer of review that Congress probably would have put in the original NEPA if they had time, but they didn't quite get to it. And Ed Muskie, the famous senator who gave us a lot of our environmental laws, was in control of the committee that was writing the Clean Air Act. So he stuck that in the Clean Air Act in late 1970, even though it's not an air provision, and it's an extra set of eyes on NEPA compliance.
Perfect. Thank you so much, Jim and everyone. So we have another question on environmental impact assessments, and whoever would like to take it, just feel free to jump in. So this question is, are EIS documents becoming smaller as a result of the expansion of CAT-X's and other developments? Is there a trend towards shorter EIS documents?
Okay, I'll take that one too. So
perfect. Thank you, Jim.
The NEPA regulations always anticipated EISs not being that long, 150 pages, 300 pages or thereabouts, and the EA a concise document. Over the decades, they got longer and longer because there was this kitchen sink approach of let's put everything in there because if someone sues us, we don't want the court to say you failed to consider this impact or this that alternative. So they grew and became more complex. So then some of the notion was if we could promulgate CAT-X's categorical exclusions, we don't do either an EIS or an EA because we just determined in advance that these are simple routine actions. So that has nothing to do with page length. That's we just, it qualifies for CAT-X. We don't do it at all, these documents at all. The trend, I think, which the Trump regulations rode was, let's put some time limits and page limits on both EISs and EAs in order to rein this in. And I think had they just done that, that the changes would have been widely embraced. And I think the Biden administration may retain some of those page limit assumptions or preferences going forward, even if they reverse some of the other dramatic changes that were made substantively. So I expect to see some shorter documents because of this overall trend, but it's not because of CAT-X's.
Yeah, to highlight what I think Jim is saying is it actually may result in longer average analyses because you're not doing the analyses at all for the things you're excluding, right? So like the universe of projects that get an EIS is small. It is the most complicated projects that tend to get that level of analysis.
Yeah, it's about 200 a year across the entire federal government. That's not a lot of actions.
And I would just add, so I actually did recently work on a NEPA case, a piece of litigation where the plaintiffs were arguing that the Nepa review was insufficient, which is typically what plaintiffs tend to argue in the Nepa context. And the bulk of the argument was that the agency decided to go the categorical exclusion route. And when I started diving into the agency's use of the categorical exclusion, it was about a 10-page NEPA analysis that at a fairly high level assessed potential environmental impacts from a project. And it turns out that, I think as both of the other speakers mentioned, like we are seeing a lot of agencies moving towards preferring the categorical exclusion because it's less work for them, it's less time. And I don't know if the number of pages of categorical exclusions have decreased over time, but I know that they can be very short documents. So the more agencies that are using them, the shorter sometimes they can be.
They're supposed to be really short, almost a checklist. One of the things I want to be clear on the question is you cannot segment a project or project's effects into pieces. So you can't say, oh, the ramp to the airport is categorical exclusion because that's just the repaving project, and the restoration of the meadow off the end of the runway is a categorical exclusion because that's just the restoration project, and therefore what's left, we're only going to look at the main airport renovation as an EIS or EA. You can't pull a project into its pieces. It's a major federal action with significant impacts. You have to do the whole thing.
Perfect. Thank you so much, everyone, for that very robust response. So moving back to the ESA, one participant has a question. Does the ESA differentiate between organisms that fill an ecological niche in their environment versus organisms that are less important to have in their habitat? So for example, I'm assuming keystone species versus non-keystone species.
Definitely. I love this question. It brings me back to my environmental science class in high school, which is what prompted me to want to become an environmental lawyer, especially learning about species that had a very narrow subset of conditions in which they can thrive and which play a key role in ecosystems. And I will say off the top of my head, subject to whatever Jim and Marna think, I have not come across express references in the Endangered Species Act to keystone species, which kind of makes sense given that it was promulgated back in the 70s. But what I will say is keystone species are obviously important to ecosystems for a reason, and that's because they are so integrated with the local environment that they help it survive and it helps them survive. And that will be factored into the 5-factor evaluation that these services use in determining whether a species is listed or not. And that 5-factor evaluation does consider the extent of current habitat destruction. So if a keystone species is imperiled, then that species' ecosystem is also, and local habitat is also likely to be imperiled as well, which means that that species would be more likely to sort of check the boxes for the agency seeking to list the species as endangered. And that also relates to the definition of critical habitat, which I did discuss earlier, and that's those areas that contain physical or biological features that are essential to conserving a species. So I guess short answer is kind of to that answer. And Jim and Marna, I don't know if you've had any particular experience with those types of species.
Well, I was just going to add that there is another element at play here, right? Because many of the listing decisions are prompted by petitions or interest outside the agency. And I think it's common for the keystone species and the species that people, recognize and relate to kind of be elevated by, advocacy groups or generally kind of embraced by the public in a way that does result in them sometimes getting a bit more attention from the agencies.
And the agencies then prioritize or might prioritize those. But from a legal point of view, the Act doesn't care whether it's important or, we love the species or not. The question is whether or not it's likely to go extinct. So the question really is it a listed threatened or endangered species or a candidate species? But, it could be one of, 17 mollusks occupying the same ecological niche. But we don't care from a legal point of view whether, the disappearance of this one, will change the overall ecology of the stream. It's all these species are in the eyes of the law equally important at the listing stage.
Perfect. Thank you everyone again for that incredibly detailed answer. So we only have 5 minutes left, unfortunately, but we'll try to go through as many questions as we can. Thank you again to the participants for sending through so many excellent and really fascinating questions. So for our next one, we have question for the panel. Some agencies have Nepa handbooks or other implementation documents that provide additional guidance. Some of these handbooks and additional guidance documents outline additional Nepa categorical exclusions that are not set forth in the regulation itself. Thoughts on potential legal challenges to applicability of these additional exclusions?
So a categorical exclusion has to have gone through a public notice and comment process and been approved by CEQ in order to be used. So historically, many agencies just kept the categorical exclusions in their handbooks. They didn't put them in the Code of Federal Regulations, and that's perfectly fine. Over time, most of them then moved to putting them in the CFR so they're easy to find. But the key is, have they been through the public notice and comment process? Is there a justification that these normally do not have the significant impact, and CEQ has approved them?
Excellent. Thank you, Jim. Now bouncing back to the ESA, Brian, if you could elaborate on conservation banking under the ESA and any regulatory changes on that note.
Yeah, certainly. So that is definitely a big area and one of those hot topics that has been somewhat controversial between the Trump administration and now the Biden administration. So a conservation bank is essentially, it's a type of off-site compensatory mitigation process to limit impacts on endangered species. And historically, over the last 20 to 40 years or so, DOI has sought to balance natural resource development and conservation by requiring that any environmental harms to species are offset by other actions, such as payments for land restoration or other areas. And under the Obama administration, we saw a shift towards greater mitigation members, including a handbook by the Bureau of Land Management and FWS. And then the Trump administration withdrew those policies, and after requesting comment on some or most of them. And obviously that has been controversial over the last few years, and a number of governors have in response called for federal agencies to again develop their own compensatory mitigation and banking practices, including ones that align with state goals. And many states have stepped up in this area. I know that California has done some work here. They have a law in the books that governs advanced mitigation credits that try to tie the distribution of those credits with FWS's regional conservation investment strategies. And the goal is to get conservation banking part of like the early stage, when I talked about the process earlier on, where typically we want to start endangered species reviews very early on before money is exchanged, before anything hits the ground. And compensation banking is typically a big part of that process to offset any losses to habitat.
Perfect. Thank you, Brian. And thank you so much to all of our participants for sending in so many questions. With only 1 minute left, we'll end on this question. Apologies as we didn't have time to answer everything, but here we go for the last one. So one participant writes in, it seems the Biden administration has yet to take action to reverse the Trump administration's Nepa regulation rewrites. This panelist asks, why is there this slow pace? Given the Biden administration's professed commitments to take stronger stance on environmental protection issues, shouldn't this be an easy decision? Or if not, what kind of issues are holding this up?
Marna, you should take this one.
I think it's probably not an easy decision because the regulations, as Jim described, were indeed quite old when the Trump administration decided to amend them. There are a few things in the amendments that I would guess this administration thinks are good things. More explicit language that goes to tribal government participation, for example, which was a big gap for a long time. I also think that this administration is trying to think through how their NEPA obligations interplay with their desire to do things like build a lot of transmission and a lot of renewable energy projects. So I think it's a pretty hard question. I think it's an important question. I think they're probably taking their time figuring it out.
Perfect. Thank you so much for your answer, Marna. And now we are right at the top of the hour at 2 p.m. So unfortunately, we do have to finish. I would just like to say another thank you to our participants again today for joining us and for your excellent and fascinating questions. We do hope that you will continue to join us throughout the rest of the summer for our Summer School 2021 series. Next week, we will be hosting a session on the basics of the Clean Water Act, and our expert panelists will be exploring the statute, and we so look forward to seeing you there. Finally, a big thank you to our 3 outstanding panelists today, who make up some of the best environmental lawyers in the country. We are so appreciative of your contributions to today's webinar and getting to learn more about NEPA and this ESA from you all. Thank you again for lending your insights and expertise from your careers to make this such a fascinating and informative program. Thank you all again, and stay well.